The first case to come before us this morning is Anita Hess versus Igor Ugorec. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. Mr. Donor, if you would like to reserve some time for rebuttal, if you let me know when you get started, I can keep the clock over here and kind of let you know what type of time you're looking at in terms of remaining minutes for rebuttal. We've read the briefs. We are ready to proceed with when you are, but I will caution you on two things. First, please do not use the names of any victims or children or individuals who may be over the age of 18 but would be otherwise classified as children in this case. In addition, please do not have your microphone on when you are not speaking. That way, in case we have any ambient noise, doesn't interrupt the other side's oral argument. We are ready to proceed when you are.
Thank you. May it please the court, I am John Donor and I represent the appellant Igor Ugorec. He is the father of SH. I would like to reserve 5 minutes for rebuttal in this matter, please. The first issue is whether or not the court had jurisdiction to reopen the case once it determined that the child was emancipated. It is a case of many of these issues are first impression in the 9th District. But this one is a case of first impression. In the 8th District case of AC versus VG that is cited in the brief, there was no action, very similar to this case. Mother received support, she didn't take any action. She was notified to submit why support would not change. She did not. She did not go to the review hearing. She did not submit any evidence to show why there should be a continuation of support, and she did not file timely objections once the court did its independent review and determined that there would not be continuing jurisdiction. For those reasons, the case could not be reopened. We asked that the court take that approach. If, to get around that, the trial magistrate and then the trial judge, in our case, came up with a novel theory. I looked it up in Black's and I could not find it. They said, this is not a garden variety case. There is nothing in any legal manner that I can find that defines what a garden variety emancipation case is, or whether it is not. But that is the term that is used to extend this this matter into allow the mother to ask for support, continuation of support, and a determination that this child is an adult handicapped child. SH was emancipated. There is absolutely no doubt about that. The CSEA and the trial court emancipated this child and then reconsidered that decision later. Could they do that? There is, the second issue is, once SH was emancipated, was it too late to come back and determine that this child was not emancipated and was an adult handicapped child? In the Gagan case in the 10th District, I think it was in 2011, they determined that there is nothing in the statute that extends it. In fact, the statute that allows for a determination that this child is what everybody refers to as a castle child is something that has to be raised before age 18. The appellee has cited the Fenstermacher case from Trumbull County in the 11th District. Fenstermacher goes through this great stretch of the law to come up with why the child should, a child support determination after the emancipation of the child is okay. The problem with Fenstermacher is they say, well, why should there be this strict line between having the determination of whether this is an adult handicapped child be requested after age 18 or before age 18? That's just unfair. There is an unfairness already in the law that is probably greater, but it's something that's been adopted in Castle and in all the subsequent cases, and that is the disability has to occur before age 18. That is no different in severity as what Fenstermacher is pointing out. But Fenstermacher takes a circuitous route through the probate law and tries to draw by analogy why that should happen. If the court looks at the Gagan case, it'll see a very simple, straightforward approach to what should happen. In this case, there is no evidence. This goes back to this court's decision 27 years ago on a case I argued, Ullery versus Ullery. And there was no connection, and there is very little evidence, certainly more evidence than what we have here, but not enough evidence to connect the alleged handicapping condition with an ability to be to have the adult child support himself. That is what we have here. We have, except it's even worse. There's no evidence at all. The mother testified, but did not bring any documentary support, did not call any witnesses, did not have any testimony that she went to any outside agency at all during this child's minority and to seek out help or assistance. All she said was at age 3, the child was on the autism spectrum. Dan Aykroyd, the actor and comedian, is on the autism spectrum. A mere statement that the child is on the autism spectrum goes back to exactly what the court said in Ullery, that there has to be a connection. In Ullery, there was physical and mental handicaps of the child that were documented and presented to the court, but no connection to the whether or not this child could be self-sufficient. Here, SH graduated from a private high school, is enrolled in a master's level program at a private college in Greater Cleveland. And there's just absolutely no evidence other than she's a college student is not supporting herself that supports the connection, that supports that this child is a handicapped child. I will save the rest of my argument for rebuttal. Thank you.
Thank you. Ms. Hooper Six.
Thank you. Good morning. May it please the court. Good morning, Attorney Donor. We are here today before the court, and the facts are particularly important. In this matter, there was uncontroverted evidence presented at the trial that this child at age 3 was diagnosed with autism, a neurological disorder, and receptive language issues. The Summit County Domestic Relations Court issued its first dispositive order in this case, which was dated January 5th, 2011, and that was pursuant to an agreed judgment entry by the parties establishing father's child support obligation. At that time in 2011, this child was 12 years old, well after age 3 when she had been diagnosed with these disorders. In that agreed judgment entry, father agreed to pay child support. He also agreed to pay half of all out-of-pocket medical bills, and he also agreed to pay private school tuition for the child.
Ms. Six, may I ask you a question?
Yes.
Was there a stipulation in that agreed judgment entry that the child was diagnosed with disability that would render her? Was there an agreement that she was a Castle child at that time?
There was not.
Okay, thank you.
Yes, and the record is certainly devoid of any of that determination prior to this order. When the child was 12 years old and they entered into this agreed judgment entry, father began paying, at least from that point forward, half of them out-of-pocket medical bills for the child. There was testimony from mother at the trial that father had in fact paid half of those medical bills, that those medical bills included the child seeing doctors, including for anxiety disorders. Another important part of this, the facts in this matter, is that father is a physician, mother is an RN. Both these people had particular knowledge, not just of this child, but of the medical effects and the medical diagnoses and how that was going to play a significant part in their life. Mother testified at trial that the child did graduate from high school, but only because she attended private high school and received severe help from nuns. She also testified the child was working 4 hours a week, stapling papers, I believe, at their church. And she did offer other testimony in regards to an incident of sexual assault and the child being drugged, which did occur when the child was 19 years old. Taken all of these together, the trial court issued a decision and found that it was appropriate to continue the duty of support for this child. Although father attempts to argue that there are some issues of really strict statutory construction in this matter, in that upon close to her 19th birthday, the Child Support Enforcement Agency filed its recommendations with the court to terminate support based on the child reaching age 19, and that mother did not object within the 30-day period as set forth in the statute. That is all true. However, that strict statutory construction of that child support statute without consideration of the applicable case law and other child support statutes makes the argument a very narrow one, certainly one the court rejected. The court, in their decision, relied pretty heavily on the Castle Child determination, and that, of course, is a decision from the Ohio Supreme Court which indicated that there is both a moral and legal duty of parents to continue their duty of support to children that are mentally retarded, certainly an outdated term as we all sit here today, but that's the term that was used in that decision, either mentally retarded or severely handicapped. The Castle Court specifically went on upon that determination and indicated that the Domestic Relations Court, who has jurisdiction over the child, is in a position to determine whether that duty of support should continue after that age of majority. After Castle was decided, the Ohio legislature codified the Castle Child provisions in a child support statute, which is 3119.86. That statute specifically indicates again, that there is a duty of support that which shall continue beyond the age of majority if a child is incapable of supporting or maintaining themselves. Certainly, it is the position of mother in this case that she established those factors before the court. Although Attorney Donor cites this 8th District decision that has reached the opposite conclusion of what we are asking this court to reach, it is important to note that the standard for review in this matter is an abuse of discretion. In the 8th District case, at that trial court, a parent attempted to continue the duty of support after age 18, and that court indicated they would even hold a hearing because the parent had failed to object to the child support recommendation to terminate support within that 30-day period. The 8th District found that that was not an abuse of discretion. Conversely, we also believe that it is not an abuse of discretion for this court, this trial court, to consider the equitability of the matters involved. The trial court in this matter, in using their language that this was not a garden variety case, used their discretion and determined that equitability and what was best for this child should be an important consideration. I believe that is not an abuse of discretion because that is something that domestic relations courts are charged with doing. And I certainly believe in reading that in connection with the Castle Child determination. The Castle Child established there was a moral and ethical duty, equitability. And so we certainly believe that is what the trial court did here. Instead, we are asking the court to adopt the rationale and the reasoning of the Fenstermaker case out of the 11th District. Notably, the facts of that case mirror the facts of this case almost completely. In that case, the child support agency made the recommendation to terminate support, and neither party objected within that same 30-day window. Nonetheless, the court in that matter found that the child was incapable or unable to support or maintain themselves, and that therefore the castle doctrine applied, in that there should be an ongoing moral and legal duty to the parents to support that child. We are asking this court to make that same determination.
In that case, wasn't there expert testimony from a doctor to support that?
I believe there was, yes. And that is certainly a noteworthy difference in this case, and that the only witness to testify at the trial in this matter was mother. Mother testified as the child's parent, as the child's primary caregiver, also indicating on the record that she was an RN and had been closely involved in the child's care. Although it's certainly, had mother been represented by counsel, I may very well have advised her to call an expert witness or to submit some additional evidence other than her own testimony. Mother proceeded at that matter pro se. There is no case law that I could locate anywhere across the state of Ohio that makes that a requirement. And so mother's testimony as the primary caregiver, combined with her medical license and degree, I certainly believe establishes for the record that there is an ongoing issue of the child's ability to support and maintain herself. Very noteworthy to me is that mother's testimony was completely uncontroverted. Father did not appear at the hearing. He did not offer any testimony to the contrary. Had father appeared and had differing opinions as to the child's diagnosis or ability to support or maintain herself, we may very well be in a different position. But just as mother did not call any experts, nor did father.
So the evidence as to the child's inability to support or maintain herself was what? Being lured by the stranger, the job of stapling papers.
Yes.
I think, and banging her head, I think, because she was frustrated. What other evidence was there to support that?
Was for the most part it, other than the diagnoses that were made when the child was 3
And the
years old.
diagnosis.
Yes.
Okay.
As we sit here, yes, thank you, Your Honor. As we sit here today, we are asking the court to adopt the same rationale and reasoning in the Fenstermaker case combined with the Castle Child Doctrine. It is certainly our position that in addition to the domestic relations statutes and case law, there is also probate court case law, or I'm sorry, probate statutes that are also directly relevant to this matter. Father raised an interesting argument in his brief, and one of which was that mother did not have standing to bring this action, and then certainly and because she had not applied for guardianship of the child. Our position is converse to that, and our position indicates that there are 2 statutes directly on point to this matter. First is the domestic relations statute of 3109.01, which specifically defines the age of majority as all persons of the age 18 years or more who are under no legal disability. And of course, that second part, under no legal disability, is significant in this matter because we do believe the evidence has established that the child is under a legal disability. Also related is the probate case, the probate statutes, which codifies the term legal disability. And the legal disability in that matter includes persons of unsound mind. It is our mother's position that she established that the child is of unsound mind in taking into consideration all of the evidence together, the diagnoses, the banging her head on a table, her inability to graduate high school except for support of nuns, and this incident that occurred when she was 19 where she was lured into a car and drugged and assaulted. And so we are asking the court to look at the matters, taking all of those matters into consideration, to find that the trial court did not abuse their discretion in finding mother to be a credible witness as to the child's disability, although she did not produce expert testimony. Thank you.
Thank you, counsel. Mr. Donor, you have 5 minutes.
Thank you, Your Honor. Page 9 of the appellant's principal brief, first brief on the merits, I list the I think 9 different occasions in the transcript, and mother testified that she was seeking safety for her child. The request she was making was not because of a disability. The request she was making was because a tragic event occurred with her then adult child after the termination of support. The Fenstermacher case is interesting for no other reason. It suggests that, and it says, if the adult child were subject to guardianship, several safeguards would be in place. The probate law does not apply here. If a parent wants to have that determination that a person is of unsound mind, that has a different application than it does because that deals with whether or not there are grounds for guardianship. But there are, if there are grounds for guardianship, mother didn't take any steps in probate court. So concerning, and what the court has already picked up on, in the Fenstermacher case, there was a psychiatrist who testified. There are cases that are cited in the reply brief, a number of cases that Armstrong versus Valley in the 7th District, there was testimony from caseworkers from a group home and vocational assessment or vocational workshop group called the Gateways to Better Living that testified about the abilities of the child. In Odie versus Odie 8th District case, the child was in assisted living and people came from that facility and testified. In Bragg versus Gorby, there are stipulations to that effect. Here, mother didn't meet the burden, didn't even get the threshold of that there was a disability. The fact that she is an RN is irrelevant. That is like saying, because I'm a lawyer, I could easily handle criminal cases at the highest level.
Of course, this is an abuse of discretion standard, and the evidence was uncontroverted. I mean, he did not appear to testify or present evidence.
The evidence was uncontroverted, but it was not sufficient.
You're saying it wasn't. How do you reconcile your strict interpretation of 31-1991 with Castle?
The Gagan case spells that out very, very clearly. That when the legislature enacted 31-1986, it had limiting a language in there, and the Gagan court said if they didn't want it limited to continuation of support, they wouldn't have included that language. They would have just left it out, and then the Fenstermacher case would not have had to go through the analogy with probate court law and all. But the Gagan case, the Gagan court spelled that out fairly clearly.
Thank you.
That's all I have. Thank you.
Thank you both for your presentations today. Thank you for agreeing to be present via Zoom. The court will take the matter under advisement. We will issue a decision which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Thank you again.